The other one that I'm very pleased to see is that the dreaded Swain case, which has driven us mad since about 1995, has virtually now disappeared. The provisions, particularly the section 64(2)(c) of the 87 Act, have virtually been eliminated because the reference and the power given to the tribunal to decide on the circumstances of the case has been eliminated in a very large proportion of this bill. So it virtually takes away the effect of the Swain case, and it makes it very difficult to create another Swain case.
Tim, can you
remind
us what the Swain case is again?
The Swain case was to do with the no blame eviction under section 58, and prior to the Swain case, all you had to do to get an eviction was to have the notice of termination properly prepared and properly served. Then, after the matter of Swain, the matter was taken to the Supreme Court and went through an appeal process. And it was fought on the basis of section 64(2)(c), which said that the tribunal, having considered the circumstances of the case, it was appropriate to make the order. And that virtually came right through all terminations, and you're still hearing it today. When they come to an end of a case, they will say, are there any circumstances that should be considered in this matter? Well, now that in this new law, that's virtually been eliminated. And so that's a big relief to a lot of us. I think that we don't have to be there justifying right down to the end. If your case is properly prepared and your notice is properly served, you're going to get your decisions.
So what else with the balance of hardship in the law?
There is a provision of hardship in the bill, which hopefully with time we'll have a look at, but it's very similar to what's in the current legislation about breaking leases on hardship. But the difference being is that the break fee doesn't, if the tenant gets up and walks, the break fee doesn't apply unless it is part of the actual agreement. So you're going to have to make some commercial decisions, but I would think that most real estate agents would want not to have that in there, because that opens the door for you to collect other compensation, which is very similar to the compensation that applies under section 78, where you can apply for the reasonable releasing costs, rent up to the date of abandonment and all that sort of thing. So virtually put that back in place. I don't think they like doing it, but it's there. And if you've got that break fee section in there, then you're in a position that you can then look to compensation other than that's the 4 weeks of rent. Okay? The other one which caused me a great deal of concern, I think some of you mightn't have really picked up on it, but the provision that you had to issue receipts for cheques and post them. Okay, it didn't seem to be a big issue, but anybody with a large rent roll who was just leaving a lot of payments through the mail by cheque, the way the original draft put it was that you would have to produce the receipt but also post it to the tenant within 7 days. That's gone. You're back to the situation that you are pretty well right now. So that's a big win. On what would sound like a very small part, but if you're running a very big rent roll, you can imagine the cost of postage. For every cheque that came in, you'd have to send out a receipt within 7 days. So that's a fairly good win. Ones that have been watered down, but we're still not terribly happy about, was the minor and cosmetic repairs. Now, cosmetic is gone. That's not actually mentioned in the legislation. It was in the draft bill, but it's now not there. So we're now only talking about minor alterations and additions. Okay, and I've got a section a bit later on which is going to deal with that. But we're not really happy with the way that landed, but it's there, and the biggest concern is there is still no definition of what is minor. What is an alteration and what is an addition? There's no definitions in the Act. Maybe we'll see some of those definitions in the regulation. Who knows? But at this stage, the regulation is a mystery, and if they're going to try and get it in before the end of this year, they need to produce that fairly quickly, because people have got to get their heads around it, and then also start planning on how to deal with the regulation. The only thing that is encouraging, because a lot of the current regulations from the 87 bill are now in our current new Act, they've given us an undertaking the regulations will be a lot shorter. I don't know whether that's good or bad news, frankly, but that's one of their one of the government's statements quite recently at our meeting at Fair Trading. Terminations for non-payment of rent, and I've got a whole section of. We're not happy about the way that finished, but it's now back to being a workable part of the new document. So, one thing to keep in the back of your mind while we're talking today, if I mention section numbers to do with the new bill, don't get confused with the 87 Act. The whole thing has been renumbered. So what was section 68 in the old bill is totally different in this. So you've just got to, when you get the opportunity, and you should do so, is download the new legislation. Make sure you get plenty of paper in your copier, because it's, as I say, it's about 135 pages, but it's certainly worth your while, and if you're a full-time professional property manager, it's a must. You've got to have it, you've got to know and understand it, because that's the basis of where you're going to make a living. Probably the good points is, because it's going to be more complicated, your rent rolls might start to grow a bit, because a lot of the landlords will be saying this is all too hard. You experts do it for me. So maybe there's a growth factor in it there for us, for the property management people. But that's just picking something out of the air. But I think it's something we should be aware of and look for opportunities. Now we've got the law, we need some opportunities to grow our businesses to give greater service to your clients. Okay. We mentioned earlier on that we're making our own interpretation of this law. The final interpretation of it is going to come out of the CTTT and the courts. Okay, now let's move on to premises that are included and excluded. So the standard premises, we're very similar to the 87 Act. Borders and lodges are still not part of the legislation. We believe that the regulation will provide some exemption for university college type accommodation and for other non-profit student accommodation. So there will be, that sort of will be expanded a little bit more to include those. The holiday rental situation has been that you've now got a general exemption for leasing for holidays for not less than 3 months. The current legislation is 2. I think the only thing that you can take away from this is to be very careful of short-term lets. If you have a short-term let which you think might be classified as a holiday, and it becomes a general letting, then you've got a lot of things to comply with. And if you don't then get yourself a proper formal tenancy agreement, then you're in a situation of not being able to act in the normal way in relation to the termination of it. You can't apply a 90-day non-blame termination order. And very small things like that which you'll need to be aware of. It's not a huge issue, but just keep it in the back of your mind, there's been some changes in that.